So, I think it's a pretty good time for us all to have a little talk about corporate exploitation. And by us all, I mean you all and me specifically. Why should you have this talk with me? Well, I'm kind of a niche human. Like a madman, I've been filing lawsuits nonstop for the last 4 years against all the trashy corporations that take advantage of us. I'm not a lawyer. And because of that, I'm willing to tell you some things that lawyers are never going to tell you about why corporate exploitation happens, why it doesn't have to happen, and how we can fix it. I think we've all been waking up to the fact lately that many of our institutions are completely broken. What I'm going to tell you today is that the legal system, too, is completely broken. It's a rigged game, and that's why we're constantly being exploited by the rich. Give me 20 minutes today, and I'm going to show you how the legal system, too, is a completely rigged game, and how the legal system itself is actually the reason we're dealing with nonstop corporate exploitation.
So, to begin understanding this problem, you're going to need a basic understanding of what the stages in a typical civil lawsuit look like. For our purposes here, we can break the typical civil lawsuit down into three major stages: pleading, discovery, and trial. For our quick rundown, let's start backwards. Trial, first off, is a lot like you would expect from seeing it on TV. Trials where a judge or jury weighs evidence and decides the cases. Simple enough. Before that, discovery is where both sides swap info, gather evidence via depositions and documents, and level the playing field. Discovery is where we clarify issues and ensure cases rest on real evidence. Now, pleading, the first stage, is what I'm going to tell you about today, and it's where everything goes all wrong. Pleading is supposed to be simple. Plaintiffs state their grievances, defendants get fair notice of the claims and legal basis, and that's it. But today, pleadings become a circus. Defense attorneys exploit every issue under the sun to kill cases before discovery or trial. They argue every technicality: wrong court, vague claims, late filings, ancient precedents, anything they can to dodge accountability for their corporate clients. Attorneys are constantly filing dilatory motions to delay and drain plaintiffs, while hourly paid lawyers on both sides bicker over trivia. None of these practices ever touch on the merits of a case. It's a maze of case law and statutes so dense, you pretty much need a $500 an hour attorney just to navigate through it. Instead of a notice tool, pleading has become a gatekeeping tool, completely locking regular people out of the courts. In a functioning legal system, and in our modern legal system, according to the federal rules of civil procedure, the entire purpose of pleading is to provide fair notice to defendants and nothing else. And the problem in pleading is that we have moved far, far away from this standard. Now, you might be thinking there's a good reason for all this technical sparring. Nope. I have dug into pleading's history, and I'm going to explain this so clearly with sources from inside the legal community that you will have no problem seeing this issue for yourself by the end of this video. The difficulties with complicated pleading practices are not new to American society. This is something the legal community has done many times throughout history to different legal systems in different countries, slowly overcomplicating them to the point of unusability. In recent history, this problem came to a head in the 1930s, simultaneously here in America and in England. By the 1930s, difficulties with pleading became so bad that even attorneys were complaining that the system was completely inaccessible. Richard Marcus wrote an extensive essay about this trend called The Revival of Fact Pleading under the Federal Rules of Civil Procedure in the Columbia Law Review. He wrote, as pleading practice prospered, decisions on the merits became increasingly infrequent. Over time, it became necessary to use highly stylized verbal formulations to present even simple grievances. These expressions, known as color, often had little relation to the underlying facts of the particular case. They certainly told the defendant little or nothing about the plaintiff's claims, and the defendant would remain in the dark until trial because discovery was limited or non existent. Nevertheless, the defendant could take comfort in the prospect that the plaintiff could ultimately lose because his lawyer bungled the pleading war. Popular dissatisfaction with this situation in England led in the late 19th century to abandonment of the forms of action and simplification of pleading. In place of stylized verbiage, the code directed that the complaint contain a statement of the facts constituting the cause of action in ordinary and concise language, without repetition, and in such a manner as to enable a person of common understanding to know what is intended. So, with difficulties so insurmountable trained attorneys couldn't overcome them, the American judiciary decided in the 1930s to rewrite the judicial rules, and they put their best minds to the task. This is when the Federal Rules of Civil Procedure, the FRCP, the rules we still use today to govern civil lawsuits, were written. As Benjamin Spencer writes in The Restrictive Ethos in Civil Procedure, the purpose of these new rules was open access to the courts and to facilitate resolution of disputes on the merits. A large focus of these new rules, as Spencer describes clearly in The Restrictive Ethos, was the establishment of notice pleading. Notice pleading is exactly what I described as the purpose of pleading earlier in this video: to describe the nature of a complaint in a way that a normal person can understand, and nothing else. This was widely understood among the legal community for decades until recently, and many legal experts have written about it pretty extensively. The goal of Dean Clark and the other drafters of the federal code was to make sure matters of justice were decided on merit after full disclosure through discovery, because they knew pleading would never be a good substitute for a jury trial. The modern use of pleading for all the technical sparring I've described is in actuality so harmful and counterproductive in the legal system that Dean Clark wanted to do away with dispositive motions altogether. Marcus wrote in Revival of Fact Pleading, at first, Clark favored eliminating pleading motions altogether. Ultimately, other voices held sway, but Rule 8A2 was drafted carefully to avoid the use of the charged phrases fact, conclusion, and cause of action. To make the point clearer, the drafters prepared a series of form complaints that were by definition sufficient to satisfy the new standard. These forms were startlingly brief. For example, Form 9 preempted decades of pleading litigation by declaring sufficient the allegation that defendant negligently drove a motor vehicle against plaintiff. No longer would the objection that negligence was a legal conclusion hold sway. Let's stop for a moment and really digest this. The current federal rules of civil procedure are exactly the same rules these legal scholars are describing here. Now think about any lawsuit you have ever seen. They are long, technical, and hard for lay people to understand. They are certainly a far cry from anything resembling a Form 9 complaint, which easily fits right here on screen. Why are modern lawsuits so large and cumbersome in comparison to this short, plain statement? Because lawyers are increasingly front-loading complaints in an attempt to beat the inevitable 12B motions to dismiss that they encounter in their efforts to win the pleading war. As you might imagine, this is a pretty bad self-feeding loop. Complaints become bigger and more complex to attempt to fend off 12B motions, and 12B motions become larger, more complex, and more frequent in attempts to kill these larger, more detailed complaints. This circus has brought us right back to the circumstances that prompted the writing of the Federal Rules of Civil Procedure in the first place. This circus turns pleading into an expensive, wasteful process that really decides nothing of substance, as Dean Clark would say. Clark's protege, Professor Moore, wrote, Clark had little patience with the use of the mere formal motion to challenge the sufficiency of the pleadings because it really decides nothing of substance. So, how did we get here? It's a two-part answer. First off, like Marcus described in the Revival of Fact Pleading, and just like you would imagine naturally, attorneys progressively push for this state of affairs over time continuously because it gives them much more room to create billable hours where no good cause for more hours exists. Second, and more specifically, this problem has been exacerbated by a really bad Supreme Court ruling. A ruling, in my opinion, that's even worse than Citizens United. Bell Atlantic Corp. v. Twombly. Twombly is mentioned in practically every single motion to dismiss that's filed in civil lawsuits today. The majority justices in Twombly, without amending the FRCP or any statutes, codes, or laws, and even without a request from any party to this suit, basically established an entirely new pleading standard, plausibility pleading, to replace notice pleading, the standard required by our modern FRCP. The Supreme Court majority in Twombly turned pleading entirely on its head by creating a very high bar for litigants to overcome to get through the pleading stage of a lawsuit and onto discovery, and they did so without going through any of the established legal methods of reform available to them. This ruling took away our ability as citizens to decide the merits of cases in the form of jury trials and gave this ability to judges in the early pleading stages of a case instead, before any evidence is ever introduced. As the courts stand now, normal people have almost no ability to bring large corporations to accountability by way of jury trial because there's no way they can afford a lawyer or get through pleading without one. This right here is the source of all our woes with large corporations and the courts protecting them in the legal system. Nowadays, any combination of judges and attorneys can dismiss or prolong any suit at their leisure in the system, and judges do now dismiss most suits that should go to trial and pleading. The statistics are really alarming, and legal experts like Mark Galanter have written about it extensively, like in The Vanishing Trial, an examination of trials and related matters in federal and state courts. Galanter wrote, "Within the courts, judges conduct trials at only a fraction of the rate that their predecessors did, but they are more heavily involved in the early stages of cases. The portion of federal civil cases resolved by trial fell from 11.5% in 1962 to just 1.8% in 2002, continuing a long historic decline. More startling was the 60% decline in the absolute number of trials since the mid-1980s. My own research has confirmed this trend has continued since Galanter wrote about it. Jury trials per citizen has fallen from 0.0015% in 1962 to an all-time low of 0.0004% in 2023, the latest data available. Now, you might be wondering if I've misinterpreted what happened here because I'm not a lawyer and only professionals know what they're talking about. I would encourage anyone who wants more background into this issue to take the time to read the dissent in the Twombly case for themselves. The majority ruling was so bad the dissenting justices pointed out this was already settled case law for over 50 years, questioned the motives of the majority justices and implied they were serving corporate interests, pointed out the ruling was a dramatic departure from settled case law, actually called the majority opinion mind-boggling, which I really appreciated because it was very cathartic to hear after my own experiences with pleading. They implied the ruling was a vehicle to illegally circumvent established precedents and called it glaringly obvious. And they concluded, rightly, that this ruling would damage the administration of justice far into the future. This ruling was in fact so bad that it is now the topic of multiple legal essays and books. It's certainly not just the opinion of a grumpy pro se litigant like me. In a well-pleaded argument, Elizabeth Thornburg writes in the opening of her essay, "I should start by putting my own bias on the table. I think the changes to pleading standards brought by Twombly and especially Iqbal are a really bad idea. Procedural systems that turn on early pleading of factual detail have failed for centuries to provide either accurate or efficient results. Rather, gatekeeping based on pleadings encourages and rewards pleading disputes, leads to wasteful motion practice about degrees of particularity, and worse, the dismissal of meritorious claims. I couldn't have said it better myself. In summary, the replacement of notice pleading with plausibility pleading is why it is prohibitively expensive and difficult to file and litigate a lawsuit. The prohibitive cost and difficulty of litigating a lawsuit is why too few successful consumer lawsuits are filed against large abusive corporations in the first place. And the lack of lawsuits generally filed against large corporations is why corporate malfeasance is completely out of control now. There is simply no significant or regular cost or accountability for corporations who pad their bottom lines with illegal practices. And there needs to be accountability for these illegal acts for these practices to stop. Our current problems with corporate malfeasance and lack of corporate accountability can be visualized very much like an economics problem. We are way off on the top left of this chart right now. We have too much corporate malfeasance happening because the costs, the legal penalties for corporate malfeasance, which would come in the form of more lawsuits and judgments, are not enough to discourage the significant malfeasance we're experiencing. We are currently far into the top left side of this chart, and it's starting to show in hundreds of different ways. Lack of meaningful access to the courts is breeding widespread contempt for all our institutions because people with honest grievances have no legitimate way to resolve these grievances. Their frustration is growing every day to the point of explosion. This growing contempt for all our institutions and the rich people running them results in things like cars being vandalized and set on fire, protests up and down the country, nonstop social media warfare, and has now even spawned assassins like Luigi Mangione that target the rich for exploiting the poor. Our socio-political situation is obviously untenable. And, I get that it's easy and convenient to blame the individuals across our country, typically the people who are politically opposite to us, for expressing all this rage and malcontent, but it isn't right. It is not right to blame the J6ers or Tesla burning malcontents or any of these other protesters for the many problems we have while the legal system, the place where people should legally be able to go to resolve their many fair grievances with the upper class, is inaccessible to 9 out of 10 people. It isn't rational, it isn't ethical, it just isn't right. And I hope none of you get me wrong here. This isn't a pitch for or against capitalism or socialism or communism or any otherism. There will never be an end to malcontent on either side of the political aisle or in any political structure or ism while there is no legitimate working legal system for the dispensement of justice. We must have safe, legitimate, and nonviolent means of solving our grievances, especially with the upper class, to have a working society. John F. Kennedy famously said, "Those who make peaceful revolution impossible will make violent revolution inevitable." And I think JFK was dead on the money here. I think we as a society are ready for revolution. And I think ideally, we all want peaceful revolution. And I think taking back access to the courts and opening the gates of justice is the most important step in getting there. And now we come to my ask. I have filed an outrageous lawsuit against the judiciary, against really the entire legal class, over our broken pleading system. Much like the legal class has recently been including all of us, everyone in the country, in class action lawsuits and settlements you've never heard of. Just take a look at the Oracle lawsuit and have your mind blown. I have included them all in a defendant class action lawsuit. I'm calling them all out over our broken pleading system. In a type of lawsuit, a defendant class action, that's so rare it's referred to as a unicorn. And today, the same day I'm filing this suit, I've come to the internet to ask you directly to please help me with this by bringing attention to this issue. Public pressure is the way to convince the judicial system to do the right thing here. Hitting those like, retweet, and follow buttons will help me take this to the end. Like you, I want clean, healthy foods. I want reliable access to the money in my bank account. I want my phone to stop ringing off the hook with spam callers. I want to sue big business right out of single family housing. I want affordable and accessible health care. And I want big tech companies to see the reckoning we all know is long overdue. The only way we'll ever solve these issues is to open the gates of justice back up, the way our legal system is designed to operate, so anyone who wants a jury trial with their peers to solve these issues can get one. Why should you help me with this? I will never have a subscription fee for any of my content or ask you for any money. I will never be monetizing my social media accounts in any way. I'll never be compromised by any organization, corporation, rich person, or political party. I don't believe in any of that. I am a solo act, and every dollar I have made for 4 years now has come directly out of the Christmas bonuses of the executives running the malfeasant corporations we have all come to hate after I sue them personally with my own two hands. The only thing I will ever ask you for is to help create the public awareness necessary to conquer these issues. We together can turn our legal system into a working system that serves all people fairly and equally. The truth is here, I've done my best to do the work first before asking you all for this help. I have read through and cross referenced thousands of pages of case law, statutes, codes, legal essays, and history to make sure I'm well informed on this issue before I talk to you about it. I hope I did a good job here explaining our problems with the legal system, and I hope you enjoyed my video. If you want to see any or all of the changes I'm describing here, please help me out. Please smash those like, retweet, and follow buttons, and I promise I will take this matter as far as I can with your help. Thanks for your time today.